Hello, my name is James Hackney. I'm the Dean of the Law School, and I am here to welcome you all. This program developed from a full-day conference on labor and employment issues that began in 2006 with the leadership from our own Carl Clare and Mark Irvings. Each year since, Northeastern University School of Law has focused on timely topics and featured a mix of prominent NUSL graduates in the labor law field, as well as highly accomplished and prominent practitioners from other law schools. This year, we will hear about labor and employment insights from two prominent members of the Judiciary, Associate Justice Mary Sullivan, class of 1981 in USL, of the Massachusetts Appeals Court, and Judge Indira Talwani of the U.S. District Court of the District of Massachusetts. Thank you both for joining us today. We will also hear about the implications of the Me Too movement for attorneys representing plaintiffs, unions, and employers. We have three terrific panelists: Beth Myers, NUSL class of 2009, from the firm of Powers, Jodoin, Margolis, and Mantell; Jennifer Smith, NUSL class of 2007, from the firm of Sanduli, Case, and Indira Zoya, class of 2012 NUSL, who is with Morgan, Brown, and Joy. We are fortunate to have Morgan, Brown, and Joy sponsor the post-panel networking reception, which allows for further discussion of the topics covered and great interactions with fellow practitioners in the field. A special thanks to Jackie Gugel and Joe McConnell for supporting this worthwhile post-event. As always, we owe a debt of gratitude to Mark Irvings, along with Ira Sills, who steer this ship so admirably each year. They always put forward timely and interesting topics. A collective thank you also to the Office of Alumni Relations and Development at Northeastern University School of Law, and to Mielle Marquis for her work both finding sponsorship and managing this terrific event. Thank you, Mielle. So it's my pleasure to introduce Mark Irvings, NUSL class of 1975, who will serve as our moderator. Mark has a practice that is entirely devoted to alternative dispute resolution and has served as an impartial arbitrator under the collective bargaining agreement between Major League Baseball and the Major League Baseball Players Association, as well as many other arbitrations. We thank him for all he has done for our labor community and for this program. Again, welcome, and I turn you over to Mark.
Thank you very much. It is hard to believe that the first one was in 2006. Yeah, a long time. And it came about because of a realization that many of the people who appeared before me in all roles, management, employment now, unions obviously, but employees in the growing employment area, were Northeastern grads, and that it was this school, more than others I have seen, has been the incubator of practitioners in the field of labor and employment law. A lot of it having to do with Carl, a lot of it having to do with Ira, before that Tom Campbell, and it's something to celebrate. We felt we could have a program that help substantively in your areas of practice, but also provide a networking experience, realization that there are an awful lot of us who came out of Northeastern who are practicing in this area. It's kind of an annual celebration. So this year, by the way, I do want to mention that Judge Talwani, while not a graduate, she chose to go to school in the West, was an adjunct professor of labor law here, so we claim her as our own for the purpose of tonight's panel. So with that, we thought, and this was actually, particularly our suggestion, the notion of let's take advantage of the fact that it is rare that there are people on the bench who have labor and employment experience. And let's take advantage of that unique time in Massachusetts history to get the judges here and to have them speak about what it's like. They were both at Siegel-Reutemann. I had the pleasure of having these people in mediations or arbitrations. They're absolutely fabulous people and they were great practitioners, now excellent judges. But to give the perspective on life from the bench, change from being an advocate, what they see in terms of what's happening in labor and employment areas that reach the bench. So with that, I believe I'm going to start with Judge Talwani.
Thanks. I'm not sure I quite get the title adjunct professor rather than I think I was a lecturer or something. I basically took over Carl's class for one term, but it was good. I think I've got about 3 minutes to do a sort of a few little bit, and then after Mary goes, I think we were going to do questions. But just a little bit about my background. I was in California in practice for the first 10 years of my practice. Arbitration, litigation, primarily union clients, but a fairly diverse subject area that we were trying to do a lot of impact litigation in there. I then practiced for 15 years with Siegel-Reutemann. Some arbitrations, collective bargaining for a few small unions, but a larger part of my practice ended up being litigation, some for my partner's union clients. They would handle the relationship and the arbitrations and collective bargaining, and I would do the litigation. And some individual, and some collective or class action, a lot of which I co-counseled with Greater Boston Legal Services. So that was sort of what my practice was. The interesting thing as I look at my colleagues on the bench is that what is unique about, I expected that what might be unique about my practice was doing labor and employment. There's not many of us. But there's actually almost no one, I think, from small firms of any sort. And that's really sort of an interesting thing, because even on the management side, a lot of the work is done in smaller firms. And the judges in the District of Massachusetts all pretty much all seem to be either having had a lot of government experience, AUSAs, or coming from big firms. But that seems to be a distinction, which as you think about practicing is sort of interesting. I've been on the bench 4.5 years now. I don't do many labor and employment cases. To the extent there's any union work that makes it to the district court, which isn't much, I recuse myself from all Siegel-Reutemann and pile room cases. That doesn't leave a whole lot of other cases in the federal district court. I have some individual employment, wage and hour, related employment cases and non-compete. So that's sort of the labor and employment end of it. I think an interesting aspect about individuals before the district court that I found shocking is that about 25% of the district court caseload in federal court in Massachusetts is pro se. Something to think about as you think about how we're handling those. And there's a pro bono panel for people to do things, but generally those lawyers are from big firms, and the pro bono work they do will not include employment work or mortgage cases, which are the other individual pro se. The last thing I just wanted to comment on is I do feel like I have a different perspective on sort of what the whole shape of litigation should look like now than I might have so much as in practice. Some of it's been influenced by watching the prosecutors in criminal cases who are a little bit more sort of cut and dry in what they're trying to do. But I realize that many of us were drawn to employment law because there's interesting stories, and wherever you are in the practice, it's really, there are a lot of really interesting stories. I think the piece that I've been surprised about in thinking about litigation in front of the courts is how much it really helps both sides, either side, to remember and figure out what your case is about legally, what the elements of your cases are, how do you prove and rebut those elements, and you know, we shouldn't be in the middle of a jury trial trying to figure out what the jury instructions are. So that's my 3 minutes.
Let me ask you this. You mentioned the big chunk of the employment stuff is pro se. Is it just employment that's pro se or just in general?
25% of what is in front of the total caseload in front of the district court. And now a corporation can't appear pro se. So I don't know what that statistic is because we don't have a way of measuring it of the percentage of individuals, but I would submit that, you know, maybe 90%. Individuals can't find lawyers for individual cases.
So let me ask this on behalf particularly of the management lawyers out there. How do you handle dealing with a pro se plaintiff as opposed to a well-represented plaintiff?
I think it's really hard for the lawyers in the room and for me. It is important to me that I'm not grooming cases simply because somebody doesn't have a lawyer. On the other hand, it's not supposed to be my job, it's the other side's job. It's hard though. And I think what I find very helpful in dealing with these cases is the more responsible and respectful the party with a lawyer is, the easier it is to sort out if there is or isn't a claim. And the more you have a lawyer who handles the pro se person by saying, okay, here's a quick fix, let's get rid of it. Or here's how annoyed I am because this is the 5th time he's sued us. The harder it is to pull it. And so, I guess my advice for the lawyers who show up when they're pro se litigants in the courtroom is that you do your clients and the court a service. The more straightforward you are, the more you don't try to take advantage of the situation and you play it as straight as you can.
Do you do anything different if it's a jury waived versus with a jury?
So let me back up a minute. We do have a mediation, the alternative dispute resolution that's available in the federal courts. We have a program for pro se litigants that for the purpose of mediation only, you can have someone sign up as their lawyer for the purpose of mediation only. The lawyer can actually decide to stick with the individual if they want, but there's no obligation. So it's a way that the lawyer can do some pro bono work and get some good experience doing mediations. There can be a lawyer in the room to help through mediation without an obligation. When we get to trial, I have offered, at the point that you get to trial, I have offered the only pro se litigant I've had who's gotten to that point. I have offered that we would use the pro bono program to find someone to do their case pro bono on the theory that so many people want trial experience that at that point we might be able to find somebody. I was turned down by the individual. He brought his own 1983 case, and he got a $70,000 jury verdict. So There you have it.
Okay, let me ask another question. It strikes me that it's very hard to get an arbitration award overturned in federal court, but it's a lot easier to get a summary judgment in an employment case compared to state court. What are you seeing sort of trends in summary judgment in employment cases in the federal court?
So I don't know what trends I'm seeing outside of my own courtroom, but I can tell you this. Every single case I have, people think that they should be filing dispositive motions. Some cases, I'm not sure that that makes sense, and I don't really understand the thinking. It's almost like people think it's malpractice to not file it, but some cases aren't summary judgment cases. When I get a summary judgment case, I do have sort of a fundamental sense that people don't understand what an undisputed material fact is. And I am regularly getting summary judgment motions with 300 undisputed material facts. And I am thinking of starting to tell lawyers, which I have not yet, but thinking of starting to say to them, an undisputed fact means that you agree that if I find this fact to be disputed, summary judgment should be denied. And I think when you think about it, the problem is that practitioners don't approach the concept of a material fact at the right level of specificity. So, for example, if an element of your case is that somebody enters the room, you don't need to tell me the story of where they parked the car. You don't need to tell me what they were wearing when they entered the room. And you don't need to jump a step and say it was an illegal entry, because that's probably going to be the application of the law to the fact. You need to get the fact, which is material that you're asking me to apply the law to, which is that this person entered the room. Don't care what they were wearing, don't care how old they are, don't care where they came in. And I get, instead, what people give me for the undisputed material facts is I get their statement of facts of the brief. I get what they would want to do in argument form, right? Normally, I want to tell my story. Here's my story. And you gotta hold back from telling your story. You gotta just give me that. But no one does. So I get these 300 pages, 300 facts. It's, you want to pull your hair. And part of the problem is, unlike in state court, and this may be part of the reason that we do get more summary judgments in federal court, is I have the case if it goes to trial. And I guess the thing I'm sort of realizing is it's really fun for me to have a trial. But it is a big ask of a jury to sit there for 2 or 3 weeks and figure out what happens. I did recently for sort of strange procedural reasons, I ended up a case where a new claim was added after the summary judgment schedule, and so we did not have a summary judgment testing the merits of it, and I ended up granting a directed verdict on that claim. The other claim did go to the jury, but it does make, I don't think that I want to suggest that summary judgment is unimportant. It does have an important feature if at the end of the day that's where you are, but you're putting way too much work on the judge to try to figure it out.
Okay, Mary. I'm sorry, Justice Sullivan. We go back very many years.
We were interns in 1979.
That's right.
For Bill Fallon, for anybody who can remember Bill. Lovely man, who I'd love to remember today, the Dean of American Arbitrators. I have been on the bench now, I'll have my 7th anniversary in December, which I really can't believe. And every year, each of the judges on the court goes and talks to the law clerks who are serving that year on the court. And they often ask, well, how did you get to be a judge? And I say, well, there was a rent in the universe and I slipped through when no one was looking. The notion that you have two union side labor lawyers from the same law firm on the bench in federal and state court, I can't think of when that's former union side labor lawyers. Now, I can't think of when that has happened. And indeed, if you look at the Massachusetts state judiciary as a whole, and I would say as an aside, the National Center for State Courts has just issued a report in which it says that 96% of all cases tried in the United States are heard in state court. Only 4% of cases heard in the United States are heard in federal court. So state court is where people's rights are being adjudicated for the most part. That if you look at the 25 appeals court judges, the 7 justices of the SJC, and the 485 judges in the trial court, I can think of one trial court judge who has a labor and employment background. That's Bob Gordon on the Superior Court. There is Judge Kafker on the SJC, because he was general counsel at Massport. And on the appeals court, there's me, and Judge Englander had a brief period as general counsel at the T. Before that, he was litigation at Goodwin Proctor. And Judge Desmond had a brief tenure representing the sheriff of Suffolk County and handled arbitrations in that capacity. Justice Budd had some period of time at Harvard doing some work. That's right. That's right. For the most part, the judiciary at the moment is turning over at a very rapid clip. There was the 2001 expansion of the appeals court, which added, what was it, either 11 or 13 judges. Most of those people have now retired. I came in as number 25 7 years ago. I am now in the top third of judges. If you know, we should be worried about that after 7 years. Like, where's the adult supervision? 7 years? Me. And I can tell you, I got a lot of gray hair. It's a sobering thought. The Superior Court is turning over at a rapid clip. We too have a large share of pro se litigants, including in the labor and employment cases. But the reason why I mentioned turnover is that you have a whole crop of new judges, most of whom have probably never dealt with a labor case because the labor portion of the market has decreased so significantly. When I started practicing, I appeared in front of Judge Nelson, whose father was a bricklayer. I appeared before Judge Mazzone, whose aunt and mother had been stitchers in the garment industry. People actually understood how that whole world worked because they had grown up in the midst of it. That is no longer the case. And in addition, the caseload for labor and employment cases is relatively low. I think the last time I was able to get some numbers on this, it was like 10% of the appeals court docket, and that included workers' comp, unemployment, labor cases, public sector labor, employment law cases, and Wage Act cases. And it's the Wage Act cases that are taking up a lot of real estate now, at least as far as I can see, at the appeals court. And they are frequently being brought by people who are not regular labor and employment law practitioners. And they're being brought, some of our recent decisions, if you've been tracking them, have involved individuals who were members of public sector unions whose private lawyers were bringing Wage Act claims that actually had implications and ramifications for the collective bargaining relationship. But nowhere represented in the litigation is the collective bargaining representative. So we have a relatively small slice of cases the cases that we're getting are actually quite complicated. And 50% of the judges on the appeals court have primarily, if not exclusively, a criminal law background. Why? Because 60% of our caseload is criminal. The civil lawyers, the former civil lawyers who are on the court, tended to be from the large firms. And of the folks who did do criminal law in the past, 3 of them are former district court judges, which means if they ever saw a Rule 56 motion, it was a rarity, and they've never seen a Rule 9a statement. So I'm sure we'll get to this in a moment, but what I come today to say to you is that when you come to court, and especially in appellate court, where we're not finding facts and we can't find facts, we can only review for errors of law. Educate, it's like the rule of real estate, location, location, location. Educate, educate, educate.
Which was, I guess I spoke at a program for judges, and I was amazed at the level of misinformation, sort of basic misinformation, such as, well, unions always win arbitration cases. If it's state court judges who are doing public sector cases, and their presumption is unions always win their cases, as opposed to unions win maybe 20% of their cases, and that they're seeing the highly unusual case. It's, I guess what I came away from, you really do have to assume no knowledge at all of the whole field when you're presenting, and I think, it probably goes for both sides. Talk about, we spoke before, talk about briefing, and because I think this applies to everybody, what you see in terms of, I just got today, apropos to our discussion about reply briefs, the initial briefs were each 60 pages, the reply briefs are 55 pages each. Judge's perspective, particularly on things like reply briefs.
Okay, if I may just step back from that for a moment to say I want to put it in perspective. The number one thing that I think I really didn't appreciate about being on the bench when I was in front of the bench, I knew it intellectually, I didn't know it viscerally, was the issue of caseload. The appeals court hears somewhere between 1,400 and 1,700 cases a year. The SJC hears 200. When I started, we were hearing 24 cases a month, 12 argued, 12 not argued, for which on a 3-person panel, it means that you're writing 8 cases a month, whether they're completely published or sent out as 128s. That's a written product every 3 days, every month, for 10 months. That's a lot. I received a case the other day, fell into my slot, randomly assigned, 19 volumes of appendix. The first volume was 1,500 pages long, and it just continued from there. They're all now given to us on our iPads. So instead of marching 12 to 20 feet of paper into my office every month, it's now all on here. But it isn't any less, and in some ways, it can be, with a complicated record like that, even harder to access, because you can't really, I'm one of those kind of out of sight, out of mind people, so I really have to devise some interesting strategies. So when you get a brief, you really want that brief to tell you what's going on, and you really want that brief to get to the point. You really want that brief to accurately summarize the record, not, what did the finder of fact find, not what do you wish they had found. because we can't do what you wish they had done. We have to do what the jury did or what the judge did. Unless, for example, it's an argument that the instruction was wrong and we had these facts and therefore the instruction had been better. But understand what the standard of review is and understand what an accurate and honest portrayal of the facts are. Because it isn't going to help you when the judge has got 24 cases to put the judge to the job of making sure that you haven't misrepresented the record. Know what the law actually is. Shepherdize your cases. Shepherdize your cases before you go to oral argument, so if there's an intervening case that actually is dispositive, you know what it is, instead of standing there like this when the judges say, well, have you read the XYZ case? And you're compelled to say, no, Your Honor, I haven't. And then there's nothing that the lawyer is going to be able to tell the judge because they missed the boat on the key thing that might have helped them win their case. So you're only 15 minutes you're going to get. And if you file a reply brief, it can be an enormously effective tool. That's called a reply brief, not a repeat brief, as they are sometimes known as. The most effective reply brief is 1 page long. The second most effective reply brief is 3 to 5 pages long. And a reply brief that takes more than 5 pages, you should be asking yourself, like, what did I miss? Because you can't raise in an appellate court in Massachusetts an issue for the first time in the reply brief. In a civil case, and you'll all be doing civil cases, if it's not raised at trial, it's waived. And if it's not raised in your brief in chief in the appellate court, it's waived. You can't salvage it in a reply brief and you can't salvage it in oral argument. Doesn't mean if you miss something you shouldn't try, but I'm just saying the panel doesn't have to accept the effort.
So when you're writing a brief in practice, you have 2 sources of feedback, right? One is your client. Great brief. I love the way you punched the other side in the face. And the other is the judge, who doesn't say great brief or not great brief. They just rule against you or in your favor. I submit to you that the feedback that the audience you should be thinking about is the judge, and you should explain that to your client, that you are aiming what you're saying to the judge rather than just to make them happy. Less is more. You don't need to get the last word because the judge only has so much time, and all that happens when you keep sending more and more and more paper in is that the judge doesn't get to the point. And the more you are completely honest and completely credible in what you're doing, the more the judge can take you at face value and not have to double check every single sentence that you give, the more likely you're going to get where you want to go. And if it is, everything is so clear and so obvious and so fantastic, you guys would have all worked it out yourself. The reason you're in front of the judge is because there's 2 different opinions, and you need to explain why your opinion is right, acknowledging that there is a debate here. Not just coming in and saying, boom, the other sides are idiots, and here's why we're right, and we are right, not even here's how we're right. So I noted when I started in this job, there was a series of articles about how a lot of Supreme Court opinions seem to have been copied and pasted from some of the briefs in front of them. Somebody had done this study. And your first reaction to that is, oh my God, how could they do that? Your second reaction when you're sitting there struggling over getting this product out is, if somebody has honestly and correctly analyzed the law, grab it if you can. I mean, I don't cut and paste briefs. I absolutely won't do that. But frankly, if you say it in a way that a judge could rule in your favor saying this, you've made your best argument you possibly can. And if you take out the adjectives when you're writing, you've got a far better chance of getting it.
I was a federal court law clerk before I went to Siegel Reitman, and the lesson I took from that was that every brief I should write, and I told my clients this, was I was trying to write the judge's opinion. I wasn't trying to write a brief.
Yeah, we talked about that legal writing teaches people to write persuasive facts or slant the facts. Slant the facts. And from my perspective, I can't speak for the judiciary, but nothing irritates me more than a statement of facts that's slanted. I mean, it's like it loses all credibility. So, I mean, for me, the way I handle my decisions is I write the facts before I look at the briefs. So I sort of insulate myself from slanted facts. But whether it's the facts, whether it's a incorrect analysis of what a case said, it's like, okay, you lose. Or a partial quoting of a holding, or even worse, a contract provision. It's not effective advocacy. You really, Mary's right, you really want to write your brief as if you're writing the decision. You let the client be upset, or explain to them that, you know, what you want to hear, I've told you over the phone, but now let me write a brief for the decider. Okay. Please, thank you.
I wondered if you've been getting briefs that explain implicit bias to you.
No.
Nope.
Because there is a guy out in the Midwest who's very active in the plaintiff employment bar, and he believes that the research shows that most people have implicit bias that they're not aware of, that it's unconscious bias. And that one of the biggest forms of bias is called availability bias.
I'm sorry, I missed it.
It's called availability bias. That is, if it's not available to you, if you don't know of women who have been CEOs, or you don't know women who have been doctors, when you hear that there's a woman doctor who's trying to get promoted, or you hear of a black person who's trying to get promoted, and you don't have that in your availability, that both men and women, white and blacks, will tend to judge someone more harshly who is not in the protected class that they're familiar with. So he is writing all his briefs about implicit bias first, and explaining and educating to judges that the decision makers in the company, the decision makers in doctors' offices, the decision makers in courts often just criticism of somebody in a protected category who's, for example, going for a promotion, because they think, well, that person probably didn't deserve it, because unconsciously it's not available to you. He's just won 5 multi-million-dollar verdicts in a row. So he is telling us, in all your briefs, start with implicit bias. But that seems very contrary to what are the disputed material facts. How would you suggest handling that?
So you started the question out with, do we see it? The answer is the place that the judges are seeing implicit bias is in trainings that we have, and there's a lot of education of the judiciary going on to talk about this. It is a discussion. You're hearing it, you're seeing it in the news and whatever. I think the Harvard University affirmative action trial that was in the next courtroom, I think there was a discussion in that from the reports of people talking about, is there implicit bias and explicit bias and so forth. So I think it is a discussion point. It is out there. I think people are in the judiciary, at least here in Massachusetts, are aware of it. I don't think practitioners are using it at all, and I don't think practitioners are thinking about it. And I think the question, if you're asking me, how does that fit into the McDonnell-Douglas framework, or how does that fit into how you're presenting it on summary judgment, I think it is another way to try to get to what you're seeing right there. Might not be as bad as you think, because people don't even realize it, you don't even realize it. But you're still, at this point, you're stuck with the case law. So I think you do have to sort of explain how somebody might be acting in this way and not having a very good self-perception of what they are doing.
In the state judiciary 2 years ago, it was one of the only all-court, all-judge mandatory trainings in the history of the trial court, because they don't like to play that card very often. Every single judge in the Massachusetts judiciary went to a day-long training on implicit bias. It has been a key component of the strategic plan of the trial court. There is a standing committee on implicit bias within the trial court. I know everybody in this room thinks about it in terms of employment law, but think about what the consequences are in bail decisions, who gets released on personal recognizance, who gets bail, how much bail. It is a huge issue. Deborah Ramirez did a study in the Dorchester court at the request of the Dorchester court on the racial patterns in, I can't remember now whether it was bail or sentencing, and charging decisions over which the judiciary under our Constitution has no control, because that's an executive branch function, but the charging decisions in drug crimes, what white persons versus black persons get charged with. So this is a huge issue that is very much on the minds of judges. In other contexts, it would not be alien to them in this context. But again, speaking as an appellate judge, the first question I would have would be, was there an expert at trial? Because where do we draw the line in terms of what we accept as argument in a brief, in terms of law review articles, and when are we tending into studies which are a form of fact-finding of which we are not supposed to, in which we are not supposed to engage. So I would, in addition to Judge Talwani's comments, I would say that the place to start strategizing is not in your brief. The place to start strategizing is in your first answers to discovery about who your experts are going to be.
And I guess the other thing I would add is that even if you don't venture away from your McDonnell Douglas, all the traditional analysis, you probably should be thinking about implicit bias as you're figuring out how you're doing your jury voir dire. And I think we're wrestling with that.
It's an interesting question of if you do it during your jury voir dire, do you get the additional benefit of sensitizing the judge who's hearing the case that they, I've learned, they have to be aware of their own attitudes during the course of the trial.
Certainly. I mean, even if you're arguing for voir dire that your judge doesn't give you, you still may be doing some educating of the judge.
The SJC currently has before it a case involving whether or not a potential juror in a criminal case could properly be struck if she said during juror voir dire that she thought that the criminal justice system was biased against people of color.
That she thought she was?
She thought, when asked if she thought that the criminal justice system was biased against people of color, she was a person of color, she said, yes, I do. Can you put that aside? And there was a series of questions and answers to that. And so that's one of the cases that the Supreme Judicial Court will be deciding this term. So it's in the state judiciary, I can tell you this issue's popping up everywhere.
Yes.
Given the lack of labor practitioners on the bench, do your colleagues come to you with questions in their labor cases? And if so, how do you advise them without sort of acting like another judge on the case?
Well, first of all, within the appeals court, discussion is permitted under the ethical rules. You can't talk up because you're trying to influence, and you can't seek input from the trial court because you're going to be reviewing the trial court's decisions. And the reason why I said educate, educate, educate is because there's an enormous isolation. If you're in practice and you get a question, You pick up the phone and you call so-and-so across the street or so-and-so across the country. In the courthouse, if we get a question, we can't do that. And so, yes, judges do discuss their cases. You would want them to discuss their cases. The only people who decide the case initially are the 3 judges on the panel. If the case goes out as an unpublished Rule 128 decision, no one else sees it. If it's published, it is circulated on what's called second panel to all of the other judges on the court, and we vote. You read the case and you vote. So I don't know whether that gives you a good feeling or a bad feeling, but that's how it works.
Joe, I'm sorry.
Well, and I would just say similarly on the, in the district court, the one thing I've sort of learned is there's this notion of Article 3ism. Nobody's going to tell anybody what to do. It's quite interesting. So in order to get any input from anybody else on anything, the only way a question will be answered, if you say to someone, what should I do here? No one will answer that question. They will say you're an Article 3 judge, you can do whatever you want. If you want to get advice, and sometimes people do, because the question would be posed as, here are facts I have, how would you handle that? Or here's the law I'm thinking about, I'm aware of, how would you approach that problem? But nobody, there's a very careful way of phrasing it and how to respond. I've had one judge tell me that what she would do when she came on the bench is she took her 2 colleagues who she knew had the 2 extreme points of view on a particular issue in general, and she would call each of them. And then she'd say, okay, now I know what my outer posts are of how to handle this. Now let me figure out what I'm doing.
Since in civil litigation, you always hear 90 to 95% of all cases settled. Right? So settlement as a practitioner is your life. It's you spend all your time thinking about settlement. I represent companies, and they want to know if the employment case is up. How do we settle this, right? And you get to ask that question the first time you talk to the lawyer, the last. What do you see, and maybe it's more for Judge Talwani than Judge Sullivan at the appellate level, but what do you see your role as a judge in that very strong reality that of cases that are filed before you, you're not going to try most of them? And when do you think about it? So is it the first time you see them at a scheduling conference? Is it before, whether status conference? Summary judgment, as from a practitioner standpoint, summary judgment is sort of the be-all and end-all of whether you're going to settle for this much or settle for this much, and the strength of your case at summary judgment. And then the specter of the jury trial, which is the thing that frightens corporate America to its knees, right? So, but settlement is the way 95% of cases resolve. So 97. How do you, what is it?
97.
97. So what do you see your role as a judge in that very central reality to the cases that are before you?
So I would say this, I was not aware of how available the ADR program is in the court when I was practicing. I knew it was there sometimes. I sort of felt like if the judge made it available for me, maybe I'd get to have it, but otherwise we had to make a decision about, I'm sorry, Mike, paying for a private mediator.
Hey.
It seems to me that nobody is saying to me that those resources are limited. So the question then becomes simply when it's effective and when it's useful. I, as a matter of course, ask people whenever I see them, not for motion hearings, but I ask people, I have a initial Rule 16 conference, I have, as a matter of course, the question of whether this is something that should be referred for mediation. I have an end of fact discovery, and I try to, no matter how the parties want to craft their proposed scheduling order, I try to set that status conference before they start spending money on experts, and I ask the question again then. I tell them at the initial status conference, if you don't know whether you're interested in mediation, go tell your client that I will be asking you that question, that I understand sometimes nobody wants to be the one to go first. So tell your client, I'm going to ask that question. my scheduling order will typically, I'll set it up whichever way the parties want of expert discovery or dispositive motions first, but I will offer that at the status conference, I will ask whether there is an anticipated discovery motion. Do the parties think it needs experts? If either side says it does need experts, then the dispositive motion won't be due until afterward. But if the parties agree that you could deal with the dispositive motion first before expert discovery, I will do that first. And then when I rule on that, I will typically have another status conference, or I'll set an initial pretrial conference. I like trials, and I don't want to make things go to trial, but I agree with you that, or maybe I don't know if I should agree with you, I think that for many cases, for the parties involved, at the end of the day, that's going to get them the resolution that they're going to want. So I'm going to try, on the one hand, to make sure that the litigation doesn't fall down along the way. I'm going to keep the pressure up so that everyone isn't just aiming for settlement, so that this can go to trial if it doesn't settle. But I also give people an opportunity to do that. The other thing that I put out there, and I very rarely have gotten any response, I sort of get a blank look a lot. I think that sometimes there's an issue that if you could get that issue off the table, everything else would fall in place one way or another. And I can't figure out how to get the parties to be willing to tee that issue up early on. Or if I do make that offer, I end up sometimes with 4 summary judgment motions over the course. So it's like nobody wants that. But I do think that parties owe it to their clients because of the cost of litigation and because of the time it takes. It just seems to me that people owe it to their clients to be trying to think creatively. And instead, what I see constantly is this notion of how do I, on the defense side, how do I give every medical test, as I sort of do it as the doctor who's trying to make sure he doesn't get a malpractice suit. Let me do every single thing before I go and get to the end of the day, because if I miss something, that's going to come back on me, and if I do it, there's no real downside. And on the plaintiff side, they either have somebody who's desperate to get the thing moving and they'll then settle short, or they need to, they also want to get a whole enormous thing and they're ending up fighting about that. So I think people should try and figure out a way to do it. And I think if you said to a judge, we agree that this issue could help us resolve things, you may find a way to cut through it.
Okay, any other questions? And if not, we thank you very much. Yes.
Before I go, I came here with a hidden agenda. When I said educate, I educate 1 in the briefs. Number 2, every judge in the Commonwealth, state court judge, gets a copy of the Mass Law Review. No one has published an article on public sector labor law in the Mass Law Review since Mark Greenbaum did 30 years ago. If management and labor and neutral got together and started putting together ideas for the law review and getting articles out there, you would be able to cure some of the knowledge deficit, because there would be an available resource that didn't come from a partisan. If you had a 3-author, and the way we always do labor and employment things, take that 3-participant approach, management, labor, and neutral, and apply it to articles in Lawyers Weekly, articles in the Mass Law Review. And the third thing is, we are in the process of discussing in the appeals court our desire to see more amicus briefs. And I cannot encourage you enough, if you see an interesting case that you think would merit an amicus brief, don't file amicus briefs just at the SJC. In all likelihood, your case is going to be decided in the appeals court. They only take 200 cases a year. And so think seriously about extending on the management and the labor and the employment side. Think about extending your amicus brief efforts, please. Thank you.
Great. Thank you very much.
Okay, we'll start the next panel in about 3 minutes.
Fast.
No, thank you. On everybody's mind currently, and labor and employment is the area where I think it hits most of all. And I thank Niall, this was her suggestion of the topic, and a very good one. So we have here a employee representative, a person who represents employees in cases, so unique issues that arise when you are evaluating cases and presenting and how they're perceived by juries. We have a management lawyer who's dealing with this both from imposing discipline, defending cases, training, and we have a union lawyer who have the unique issues surrounding the fact that union members may be both the victim and the miscreant, and what challenges it poses. So, again, I think we can probably handle questions along the way if they come up. If not, we'll do them at the end, but we try and have, we have a lot of talent, resources out in the audience, so please feel free to raise your hand, and as we go along, raise questions, make statements, short. We're going to start with Beth, employee representative. Take it away.
Okay. So the kinds of cases that my firm and I handle most often are discrimination cases, retaliation. I include sexual harassment and discrimination. And we also do some wage and hour and FMLA retaliation and a kind of a whole range. But I would say kind of the bread and butter and the most frequent call we get is bullying and just general harassment in the workplace. That's definitely the most general call we get. But the largest group of cases that we take either on a negotiation, try and resolve it, pre-litigation or litigation basis are discrimination, sexual harassment, and retaliation cases. And I guess I view sexual harassment cases a little differently than discrimination, and largely due to where we are in Massachusetts and in Boston, in where we're at in 2018, and then also what Liz mentioned earlier, the implicit bias. So I mean, a lot of I don't get cases where someone calls me and says, I just got fired and I was told I was too old, or I didn't get the job and they told me it's because, I'm Muslim. I don't get those cases. If you get a case like that and you want to refer it to someone, feel free to send it my way. But I get cases where the bad actor doesn't believe that they've acted in a bad way and doesn't believe that they've made decisions or taken actions based on implicit bias they may have. Sexual harassment is a little different. Sexual harassment is largely about actions, comments that are of a sexual nature, and it's a little clearer to pick those out. And so when we talk about having to kind of paint this mosaic picture with little bits of proof in order to prove a discrimination claim, I think the proof of a sexual harassment claim is a little different and perhaps a little clearer and less murky. I will say that the average layperson's idea of sexual harassment, just as with discrimination or probably any other potential violation, is different from the legal standard. And so I do get calls from people that say, I'm being sexually harassed at work, and I say, okay, tell me about it. And in my mind, it just really doesn't amount to a claim. It probably doesn't amount to a claim. And the claim is going to come down to, was it sufficiently severe or pervasive? If you have severity and pervasiveness, that's obviously easier. But you can have a really egregious incident once that will be enough to support a claim, or you can have a number of lesser incidents over a period of time, or just a number of them clustered together that meet that pervasiveness standard. But there's tons of conduct in the workplace that makes people insanely uncomfortable, and that can cause crying and anxiety, the morning of work, the night before work. and that can make a person's life hell. And so one thing I've learned in practice is I get, early on in my career, I get these calls and I think, what's the big deal? People don't have to be nice to you at work. People don't have to like you. They don't have to go out of their way to be friendly to you. But there are these, I refer to it a lot in kind of death by 1,000 cuts, that, if you take a snapshot of what's happening to somebody, you think, this is life, and, we can't protect everyone in every way, but when you look at the larger picture, you can see how it is really distressing. And I will say that there are lots of things that happen in the workplace that are incredibly distressing, cause a great deal of emotional and probably physical distress to employees, that are not actionable, or that I suggest maybe taking action isn't the best thing to do, and perhaps putting all the energy into getting out of that situation is a better option. In any event, sexual harassment, yeah.
Does workers' comp ever come into that?
So anytime there is, yes, claiming that you are emotionally distressed due to stress at the job, if there's any kind of work-related cause, then yes, workers' comp would come into it. I will, as a caveat, I know nothing about workers' comp, so beyond that I won't comment. Sexual harassment claims, so people come to me and they tell me what happened, and sometimes I might say, that sounds really awful, and I bet that makes you really uncomfortable, and it sounds inappropriate, like it shouldn't be happening, but to be honest, I don't know that you've got a claim there. That doesn't mean that I can't help the person try and navigate an exit from an employer, or negotiate a separation, but it's not a claim that I'm going to take to court. An added feature of all of our work is that, many, and I don't have the statistic, but many of these claims that are brought in court involve employees who are still employed at the employer. And it is always easier when you have someone who's been fired or who's left and doesn't work there anymore, because then you're not dealing with a day-to-day employee relations. And it is incredibly difficult, and a real piece of our job is, what is our role in, okay, so someone is being sexually harassed at work. They still work there. There's been a complaint filed, there's an investigation going on. I'm sitting in my office in my firm, she's sitting in her office in her firm. We're not there on the ground on a day-to-day basis. So I'm getting all my information from my client, she's getting all hers from hers. We can't be in there protecting and navigating. As you know, you can advise your client to do certain things, but that doesn't mean they're going to do those things all the time. So that is a really complicated piece of any employment, but sexual harassment too is, the accused deserves to have an opportunity to be heard and to flush out what's really going on, but you have to keep people safe in the workplace. I wanted to talk a bit about, I will say, I think that this whole Me Too movement, in general, has created more awareness that this still happens, that this isn't an issue of the 70s and 80s and 90s that's been cured by statutes that have been passed protecting this, that it still happens, and that it looks different in different situations. There can be physical touching in situations, there can be no physical touching, and it can still be really egregious. You have questions of consent, where if you have an employee who is in a arguably consenting relationship with a supervisor, is that truly a consenting relationship, or are you dealing with a power dynamic that prevents consent? I operate around sexual harassment as I think about it as a power issue and less about sex, more about power. So it doesn't really matter whether the alleged victim is male or female, or if there's straight or gay. It's about power. I tried a case in July, a sexual harassment case, and I will say that when we filed it, I had just had so 2015 is when we filed it, and the Me Too movement was not, in the news at the time. So by the time between filing it and getting to trial, the Me Too movement had blown up. And so this was a concern largely with jury empanelment, because people have strong feelings about the Me Too movement on different sides. And many people have been affected by sexual trauma, sexual assault, sexual harassment. If an individual here himself or herself has not personally experienced it, their mother, their sister, their wife, their father, somebody in their life. And so 2 things I wanted to talk about briefly with respect to jury impanelment was that we asked for attorney-conducted voir dire, to do a panel voir dire. And we were fortunate to have a judge who was very receptive to being educated and actually made that clear at the beginning of the trial. And so the voir dire process, I brought my voir dire questions. Voir dire, for those of you who don't practice in the Superior Court all that often, typically there's a large general voir dire done with the entire potential jury pool. And the court often reads through a number of questions, and you can ask the court, and often they do on their own, they'll add questions that are particular to the nature of your claim. So, in the case of a sexual harassment claim, they'll ask questions about, have you ever experienced sexual harassment? Have you ever been accused of sexual harassment? Anyone in your family, and that kind of thing. So you do cover some of the topics open to the whole panel, and people raise their juror card, and then they come up to sidebar, and you have a little discussion in private so that they're not airing all these private things in front of the rest of the group. And through that process, one thing that was eye-opening and frustrating was that so many people, so many prospective jurors had been affected by sexual harassment or sexual assault. And there were so many of them that were dismissed as a result of it. And it wasn't just, oh, okay, you've been accused of it, or your wife experienced sexual harassment. And we did then go through the whole kind of, do you think you could be impartial? And some people said, I don't know. I'm worried about whether I could be impartial because I watched my wife go through this for 10 years at her last job or whatever. A lot of people with family members who had experienced sexual assault, who either found the topic really distressing and did not want to sit on a jury that involves allegations of sexual harassment, or either the defendants successfully got them dismissed for cause, or they questioned themselves whether they could remain impartial due to their own experiences. So we lost a ton of jurors just due to the prevalence of sexual harassment and sexual assault. That was one point I wanted to make. The voir dire question. So voir dire is, after that, you have all the discussion at sidebar. If the person is found to be impartial, they're seated in the jury. And once you have 12 or 14 jurors in the box, the attorneys can do attorney-conducted voir dire, which I think it works best if it's done kind of like a conversation. And that is really hard because you're sitting there with, everything about this case, you've been studying the law, this is day 1 of trial, you've been in your office for 8 weeks straight, and you're ready to go. And they're in a group of strangers being asked sensitive questions about sexual harassment and what their personal beliefs are about it. So getting them to talk is challenging, but you have to go out of your comfort zone, and you have to really kind of, the first time I did this in March at a trial, it did not work out so well because people were just kind of like, nope, no thoughts, nope, I have no comments. And I wasn't really prepared to really kind of tease it out of them. And so in July, I was trying to ask questions about whether people in general had a sense of whether these accusations that were coming up were largely untrue, whether there were people in the jury box that felt that men or those who were accused were being unfairly targeted, or that old allegations were coming up, and it seemed more likely than not that a lot of these allegations were untrue. People started talking about whether it was helpful to frame it in terms of like, have you heard that other people might think that the majority of these claims are untrue? And then people would be like, oh yeah, I've heard that. And then they might start opening up and like, oh, and I believe that too, or because my brother was accused of it, and the woman da-da-da-da-da. The tricky thing about voir dire is you uncover the folks you really don't want on your jury, but you also uncover the people that you really do want on your jury. And then the defendants uncover the people that you really want on your jury. So you just have to be thoughtful. I also wanted to get jurors thinking, even if it didn't end up that we identified a really problematic juror, but I just wanted to get them thinking about reporting. One issue in our case was that allegations of sexual harassment had gone on for a significant period of time without a report. And you know, we obviously had a reason why she didn't report, and it was, you know, she had seen this guy get away with a ton of stuff. He was the company owner's best friend, and she believed, and we argued reasonably, that if she raised an issue of this, it would cost her job. And that at the time, she really needed her job. She really needed the money. It had a ton of flexibility that she needed for her children. She wasn't going to be able to find a job like that with that much flexibility where she could pop out and take her son to hockey practice. And she was terrified that if she made an issue of it, she would lose her job. So she just kind of hunkered down and dealt with it. But I wanted to get jurors talking about that. And I said, you know, can you think of a reason why somebody might be sexually harassed and might not report it? And that kind of question, people would talk about that. We got a great answer from a woman, and so of course, right after. But those are the kinds of questions that I asked the panel, and I wanted, you really do want to identify that one person who's like, all these accusations are BS. And then you also want to, yeah, I can be faster than that. So that was eye-opening. I think jury impanelment is going to be a really interesting process in sexual harassment claims because of the Me Too movement. Now, we heard that 97% of cases settle. Another very kind of hot topic in employment litigation in these sexual harassment claims are NDAs, non-disclosure provisions. And you know, does the plaintiff want it? Does the employer want it? And non-disclosure, basically, once you settle a case, you typically have a confidentiality provision that says we're not going to talk about the settlement negotiations and we're not going to talk about the terms of the settlement. But then you often also have a non-disclosure, which means you can't even talk about the case and the fact of the case and that it was settled, the underlying allegations. And in an employment context, some plaintiffs want an NDA. They don't want their name floating around as someone who's brought a claim. They're worried that it will affect their employability or their reputation or whatever. But many want that, and many practitioners who represent employees want that because it prevents or it makes it more difficult for employers to kind of push these people, these serial, you know, folks who have been serially accused of sexual harassment under the rug because they have, you know, they're protected by these NDAs. So that may be a segue to management side.
Okay, let me just, one quick point on that, came up in a case I did last week. Under the recent tax law, the reform that got put out, there's provision about if you have a non-disclosure agreement in a sexual harassment case, the settlement is not deductible for the employer, but it appears through some careless drafting that the attorney's fees may not be above the line deductions for the employee if there's a non-disclosure agreement. So it's something, yes, it's something to be aware of. Of course, we can count on the Senate to clean up that problem. So, Andrea, please.
I just wanted to jump back quickly to something that Beth said, and when she was talking about when there's a current employee and how those are difficult cases because we're not there. And I think more now than ever, it's important that we're, at least from our perspective, making sure that our clients are training their employees, and that's kind of our first line of defense. When someone is sitting in that room and they've been fully trained on our policy and the law and, you know, how to be on your best behavior, that's kind of the first step to making sure that things are going as right as you can, you know, as much as you can control a person that they've been giving that training. And I think that's one of the big changes that we've seen is the enthusiasm around companies who are willing to make public gestures to demonstrate that they're on board with preventing discrimination and sexual harassment in the workplace. And as a result, I think our clients are more willing to make training a priority. So I think that's been one of the biggest changes that we've seen. But Beth also talked about how the law hasn't changed in Massachusetts, and that's certainly the case. The standard is still severe and pervasive, but we have seen in other states, and we practice everywhere, but even if you don't practice outside of Massachusetts, I think it's fair to say that these new laws that are popping up as a result of the Me Too movement in other states will certainly affect how jurors or maybe judges will interpret our law, and certainly give us kind of a window as to what we can expect down the road. And one of those things is related to NDAs. So we're not just looking at the tax law changes, we're looking at statutes that are enacted specifically related to sexual harassment claims brought in the workplace. And I think, I'm not sure exactly the number, but I think 16 states introduced legislation that addressed NDAs or mandatory arbitration agreements related to sexual harassment claims, and several of those were successful in being implemented. So that's in New York, Vermont, Tennessee, California, and Washington. And even if you don't have interest there, or you're representing employees there or employers there, I think it's interesting to know that this is potentially on the horizon for us as well. So for example, in New York settlement agreements, you can't have an NDA that would prevent a person from talking about the underlying facts and circumstances that gave rise to that sexual harassment complaint. And I think that's aimed at addressing the concern that if you have repeat offenders, these NDAs are protecting those individuals. If in that New York law, if the person bringing the complaint wants to have an NDA, you can, but it's a whole nother mechanism. You have to have a separate settlement agreement, which outlines that they're doing it because they want to. You have to give them 21 non-waivable days to consider it, and then 7 days to revoke. So similar to the ADA process, but if someone's over 40, but a little bit different. So I think from our perspective, we just have to be keeping our eyes wide open when it comes to these agreements that are pretty standard and maybe haven't changed too often, and maybe employers are using the same forms that they've been using for quite some time in settlements, and there are a whole slew of things that you need to be keeping an eye on, not just in those states, because these things are being proposed kind of across the country, maybe making up for some moves that aren't being made on the federal level. So that's with regard to NDAs, but there's also laws affecting mandatory arbitration of sexual harassment claims. And we have seen a lot of corporate America trying to get out in front of this, probably as a show of good faith, and here we have this wonderful workplace, but also maybe in response to or in anticipation of some of this legislation. So following Microsoft's lead, Lyft, Uber, Google, and Facebook have all made announcements that their mandatory arbitration agreements will be optional or not apply to sexual harassment claims that are being brought. So I think that's an area that we'll probably see some changes in going forward. I think California also had that same provision proposed, but there's an issue as to whether it will be preempted by the FAA, and so the governor did not sign off on that portion of the bill, or that separate bill. And then finally, I think maybe the thing that has me most concerned, or me most interested in to see how it will play out, is potentially a shift in the legal standard for these cases. And I think that comes about most obviously in one of the bills that California has now implemented. And as of January 1st, 2019, the standard for proof of discrimination related to sexual harassment has been lowered pretty substantially. So it also establishes a directive that those claims are rarely appropriate for summary judgment. So so instead of that severe and pervasive standard, the standard is simply reasonable person subjected to discriminatory conduct that made it more difficult to do their job. So I have no idea what that means. And, no clue. And I don't think, it's going to be tough for employers to make that call. So, a dirty joke or two, is that sexual harassment? Maybe. I don't know. Is one incident enough? maybe. I mean, we just don't know. So I think, again, it goes back to now more than ever is the time to make sure that sexual harassment prevention training is happening, and making sure, especially those managers and supervisors that are the first line of defense for a company, they know their own policy, they know the law, and they also know that we're moving in a direction where it's very clear that saying I didn't mean to offend somebody is not going to cut it. And part of that is probably some education too. We're talking about implicit bias, and that certainly comes into play when people are saying things or doing something that they have absolutely no intention of offending someone over, but the reasonable person who is finding that action more difficult to do their job, I mean, that's a problem.
Right now, the standard is has to materially change the terms and conditions of your employment. So we try and argue basically that it makes it harder to do your job, but in those terms, and it's not always easy.
Let me ask this: what do you do when you've been notified that someone has raised an allegation against the CEO or some high level? Procedurally, how do you deal with that?
I mean, so it's important for our clients to quickly address and investigate any allegations, regardless of who it's against. And I think there's, in the past, has been a strong culture. If someone's a good performer, they're bringing in a lot of clients or a lot of business, to put that first. But I do think that companies are starting to get behind that having a productive environment and a productive workplace means addressing those concerns at the highest level. And we've seen companies being more and more willing to hold executives responsible. I mean, you can't turn on the news without seeing somebody getting ousted, and I think that's new.
Will you recommend that someone from the outside be brought in to investigate?
Yeah, depending on the circumstances, sometimes it's certainly appropriate for us to be the outside person doing that. Sometimes HR is perfectly capable of handling it, but I think we do see more and more our clients being concerned that these investigations are going to be under really tight scrutiny, probably more now than ever, and bringing in a third party who could do a thorough, unbiased investigation we're seeing more of that.
Okay, please.
So the majority of my work is in the public sector for unions, so Commonwealth employees, police, fire, teachers, town hall employees, that sort of thing. And pre and post Me Too, dealing with sexual harassment complaints have presented a difficult challenge for unions. The first quagmire is when the complainant and the accused are both members of the same bargaining unit. And victims of sexual harassment, or really any sort of workplace harassment, are often very disappointed to learn that the majority of unions, not all unions, see their position as playing defense. They see themselves as reacting to allegations of misconduct and preventing discipline, or negotiating a smooth exit maybe for someone, but it's not to represent the employee who's making a complaint. And I think that frequently for employees who are making a complaint, they don't understand why their union that they pay dues for is helping the person who's created a psychosexual hell for them. And that it takes a lot of tact and energy to try and explain that, it's not really the union's role, and as long as the union doesn't see that being their role, it's not going to be something the union's going to take on. The second quagmire is that collective bargaining agreements often provide for a discrimination and harassment-free workplace. And in practice, that really doesn't mean a whole lot, because unions are reluctant frequently to bring claims to arbitration over the failure to provide a discrimination and harassment-free workplace, which doesn't mean it doesn't happen, but it just doesn't happen as much as the other stuff, because unions are so focused on, again, defense, or servicing the contract through collective bargaining, or the other important and critical work that unions do. So the reason that unions are reluctant to bring claims under discrimination and sexual or harassment-free workplace is because the remedies are limited, and frequently they're not financial. Maybe you would be able to get lost days of work or something like that, but you're not getting the types of jury verdicts that people get through making private claims. And for the cost, unions are want to save their resources. A lot of unions are small organizations, and they want to save their resources for things that they feel that are going to be successful and that benefit the whole bargaining unit. And it is still, unfortunately, many unions don't understand that providing a discrimination or harassment-free workplace would be a net positive for everyone. And then the third issue is that bringing a grievance or arbitration over the failure to provide a discrimination and harassment-free workplace has a potential for a conflict and collateral damage, where you're essentially bringing a claim that would result in one of your bargaining unit members receiving discipline. So frequently, unions see their responsibility and their role in when they come across sexual harassment or discrimination complaints to steer the complaining party to competent outside private counsel to evaluate and pursue their claims rather than have it be the union's problem. And that's, there's a lot of disappointment, I think, from claimants over that. In response to allegations for sexual harassment, in my experience, both pre and post Me Too, I'm still seeing, two basic responses from employers. And the first is to just sweep the issue under the rug, so investigate and ignore. And then the second is to overreact, so take an isolated incident and turn it into a situation where you're gonna terminate an employee or demote an employee with a significant suspension. And I think that a critical piece in the post-Me Too world for practitioners in contract arbitration is that just cause still applies. So there's a lot of fervor about Me Too, and we talk about it a lot, and that's on a personal level, I think, a very good thing. But claims still need to be supported by substantial, persuasive, credible evidence. It's not enough to say, I think this happened, but I don't know because of the circumstances. Like, that's not going to be enough to substantiate discipline. And this is, in conflict with kind of my own personal philosophy, because I think that you should believe people who are taking the time and energy to raise workplace concerns, but at the same time, everybody has to work somewhere. That's kind of my philosophy about it. So if there's not a reason for them not to work someplace, then we need to move forward. And the other kind of interesting issue is that kind of the aging of complaints. Older complaints were something that happened at the 2007 Christmas party that everybody knew about and that everyone was aware of. Aren't going to be a persuasive grounds to discipline someone in 2018 just because now someone has a problem with it. And it doesn't mean that it was okay at the time, but the fact that everybody knew about it, now that it's stale, it's not going to necessarily be a sufficient basis for discipline.
Galen asked about workers' comp. Have you had any dealings with police and fire and people, particularly in police? Police has been a tough workplace for women.
Yes.
But injured on duty claims?
Yes, so it's I can think of a number of examples. Well, we talked about this in our prep call, and then I went back and thought about it. I can think of a number of examples where employees who have been subject to sexual harassment at work by superior officers, I'm thinking exclusively in a police context, have gone out on 111F status, so injured on duty pay, because of psychological injuries that are derived from their workplace sexual harassment. And that's been, it's tough because frequently, people go out on injured on duty and then particularly for psychological injuries, and it's difficult to get them rehabilitated and back to work in those situations, particularly where the perpetrator might still be employed, and the employer is reluctant to do anything about it.
And I think the employees are often reluctant, I'm thinking in a police setting too, because if in a private setting, if I'm having an emotional, distress issue, whether it's related to something that's happening at work or not, I don't have to air my personal, private, medical, mental health information to my employer. In a police setting, you then have to come back and do a fitness for duty and prove that you are, capable of doing the job. And so many people that I talk to would never go out on 111F because they don't want to deal with the invasion into their privacy around their mental health records.
Right. No, and people are always like, well, I can't. If I give these records to my employer, then they're still protected by HIPAA. I'm like, no, it's not what that means at all. But yeah, if you go out on mental health, if you get clear, what the notes from your psychologist or the provider you're seeing are going to be the evaluating physician for your fitness for duty is going to want to see those. We have negotiated agreements where someone's being sent for fitness for duty where the report is supposed to be narrowly tailored to determine whether or not they're fit to return to work, and it's not supposed to necessarily touch on the person's history of mental illness or like their child, whether or not they were a bedwetter. There's lots of things that don't need to go into the actual report and should be excluded, and employers are sometimes open to negotiating those sorts of agreements and working that out. But I think the bigger issue for police officers, particularly when they're making a claim about psychological illnesses, is so many of them are concerned that they're going to get their license to carry revoked. And in so many situations, their license to carry is a condition of employment in their collective bargaining agreement. And so if you don't have a license to carry because you have a mental health issue, you can be terminated. And it's more complicated than that, but we need to balance people's right to bear arms with their right not to bear arms if they're in distress.
I was thinking about the possible change in the standard. One thing that I've encountered is, and I hadn't thought of this term since law school, since I was here, was the eggshell skull plaintiff theory. And so one thing I have seen is potential plaintiffs who are experiencing some form of sexual harassment in the workplace who have a history of sexual trauma. And what does that mean with respect to, are they objectively and subjectively reacting as a reasonable, who's the reasonable person in that situation? Is it the person that was traumatized sexually as a kid and is now being re-traumatized, or is it the person who wasn't sexually traumatized as a kid sitting in that person's shoes? And unfortunately, based on my little anecdote about the jury selection, there are a lot of people that have, this is not the first time they're experiencing this. And what do you do in that situation? And as a practitioner, as a lawyer, how do you handle that? We're not trained. I mean, we got great training here, but I did not get psychological training here. I do a lot of psychological, heavy, communication, and I joke with some of my clients that they're, a therapist is cheaper and is covered by insurance, and, but seriously, in some of these situations, you're dealing with, from the outside, an employer might think this person is responding totally, they're totally overreacting and blowing this out of the water. And from my perspective, that might be something, in one case that what we were grappling with, do we disclose this? I mean, she was like, I haven't told my husband, I haven't told my children, I do not want this getting out. And we're like, okay, but then how do we explain that your reaction was reasonable? And I think that's probably a much more common occurrence than we're aware of all that often.
Because the fire departments and police departments are heavily male, are there a lot more sexual harassment cases and those types of?
Oh, yes.
Yeah, and I think it's really difficult for female police officers and female firefighters because, for young female police officers, even talking to older female police officers, it's like the response is, well, you don't want to be like one of those women, and it's just
the stuff that happens in police departments and fire departments today is like the crazy shit that you heard about happening in the 70s that brought about the statutes. They still happen there, and they play along until it crosses a line, and their line is in a very different place than, you know, private corporate America in my experience.
And it.
Even now, even now.
Yeah.
Well, I'm still earning a living from it. So, but you get the women saying, well, in response to, well, she joked too. And it's like, well, if I don't joke, then I'm not one of the boys, you know, hey, right, you're one of those women. But it also, it sort of ties in my mind with the notion of why people don't report, why they don't go to HR. And when I'm doing mediations and the HR people say, well, you know, we're there and they didn't come to me. And I said, well, the fear of retaliation, retaliation wouldn't possibly happen. And my experience, having done this stuff for a very long time, is retaliation happens routinely. Some HR places are better than others, but the notion of going to HR is somehow it'll be confidential, it won't be confidential. They're there as your advocate. No, they're actually there as their management. So that a lot of people will say, I didn't go, I didn't report it because I knew as soon as I did, I was dead. I was dead in not only here, but then if I make a think about it, I'm dead in the industry. And it's a tough, from then an employer's point of view, you have the problem of, well, if they don't come to us, how can we deal with it? So it's a difficult situation for the employers that are serious. I have one recently which was interesting where, I won't go through all the details, but they recently, and they've been negotiating a consent decree, but despite all that, and there's been major activity within the plant, this supervisor started heavily hitting on these women, immigrants, you know, which raises a whole other issue for sexual harassment when you're concerned about your immigration status. But the company then said, well, we found out and we fired the guy, which was great. And I said, well, does anybody know? They said, oh yeah, we let it be known all across the plant, because this guy, when we interviewed him, said, well, yeah, I had the training, but, you know, I did it anyhow. So the company then says, well, great, this will send the message to the people better than our training, that if you do it, you will lose your job. But it's a balancing act in a lot of these companies. I'm curious, have you seen people taking not only aggressive stance, but letting it be known within the company that there has been an action taken?
I think there's, just like we're seeing a kind of a shift in a culture, or maybe not when you read some news stories, but maybe a positive shift in culture as far as awareness of these issues going on. There's clients who are taking proactive steps to show that they're moving in that direction too. I mean, it's not just police stations. There are a lot of, you know, like even certain finance places where it's, you know, a hyper-gendered boys club type atmosphere, and I think we're seeing a lot of clients who maybe already had their heads in the right place of where they wanted to go or where they wanted to be, who are making, you know, more public statements with regard to, you know, here's our sexual harassment policy, here's who you can contact, here's what we want you to do, and just creating an atmosphere where people are more comfortable using the mechanisms that are already in place. And again, a lot of it comes back to training and making sure people know what's available and what will be found to be acceptable and what will be found to be you know, a fireable offense or something that can have you out the door and without you know, without a job.
Yes.
Yeah, just on that, the line that you were talking about, Mark. Do you think, you know, in terms of progressive discipline, like that concept, with the Me Too movement, that sexual harassment is kind of in that category of things you can do at your job that, you know, you're not going to get a warning or a suspension, that you can go straight to termination?
Oh yeah, certainly. I mean, I don't know that I can think of any incidents where there has been an investigation internally that has substantiated sexual harassment where that hasn't led to, you know, either a suspension or termination. I think when it comes to progressive discipline, you know, whether I think that's in a contract, that's something different than whether that's something that's been implemented in, you know, a handbook or something like that. But generally, employers will reserve the right to skip steps if something's, you know, egregious. And I think sexual harassment tends to fall in that bucket. I don't think I've seen it not fall in that bucket. But
do you think that's a change though?
no, I don't think so. However, I kind of want to walk that back, what I just said a second ago, because I'm thinking of, you know, the cases that you don't see, which is someone coming in and saying, you know, he said, you know, you look really sexy in that dress tonight, come on, you know, like, come to my office or something. You don't see that too often. So I think there are probably some judgment calls when it comes to, you know, like a dirty joke here or there. You know, does that violate an internal policy that you could be disciplined for, even if it doesn't violate the law? Yes, but you know, it will depend on a lot of things as to whether that means you lose your job, I think.
One thing that's wildly frustrating to our clients, and probably in a union context too, is that once someone complains, the investigation process in most cases is not transparent. And so often you don't know when an investigation is complete, if it was ever complete, what the findings were, what the outcome was, and whether you know, your complaint was substantiated, and if so, what action was taken. And I appreciate that there are privacy issues on both sides, where if someone's being disciplined, you know, if you're representing that person, you would want to advocate for their right to have, you know, personnel decisions remain confidential and not having it aired out. But for a complaining person, I think communication around the investigation probably leads to and could prevent a lot of claims going forward, because people don't feel heard. They think it was buried under the rug. HR or somebody might say to them, oh no, it was concluded and we handled it, you know, it's been handled. But the complainant is saying, well, how? You know, maybe they're moved out and then they feel like I'm being retaliated against because I've been moved, but the employer's saying, well, you know, we're trying to protect you. And so I would advocate for more transparency in that process. And I think that I would probably get fewer calls following an internal investigation. Because they say, you know, the employer says that it's going to be, you know, an unbiased, impartial investigator, and the person says, you know, sometimes it's laughable, and sometimes you think, okay, maybe this person's impartial. But in any event, you don't. There's no outcome. You know, the person says, I made a complaint and it just went into a vacuum.
Yeah, I think that's fair, and I have several cases now that I think one of the triggers was not feeling heard. So even though there was a, you know, really thorough investigation for the reasons that you mentioned, this is another employee who, you know, maybe had a personnel action. That's not something that you can just share, you know, and if that employees to later become a plaintiff because you shared certain information, I mean, then we're in just different sides of that discussion. But I do think effectively communicating, you know, here's our process, here's what we do, and when it's resolved, explaining that it is resolved, and if you have any further issues, here's the contact information that you call, just so that person does feel a sense of wrap up and also continued support, because I do think that fear of retaliation keeps people, right or wrong, I think that's just how people often feel. It's fine for them to feel that way. My right or wrong comment is with regards to whether or not there's actually going to be any retaliation implemented. But I do think effective communication around that investigation is important.
So I'm really struck by the idea that sexual harassment in police and fire today is similar to what might have been seen in many workplaces in the 70s. And I imagine in the intervening years, training on sexual harassment was probably similar in the public sector and the private sector. And one of the things that has changed is the representation of women in the workforce versus the representation of women specifically in police and fire. And I wonder if you think there's going to be any change in the level of sexual harassment in those fields without greater equity of gender in the employees.
I mean, I can say there's lots of employers, there's lots of workplaces where there are, 80% men, 90% men, and they don't have rampant, horrific sexual harassment. Personally, I think it's the attitude of management, and if they're either by implicitly or explicitly saying this kind of behavior is okay or not, if they're ratifying kind of ongoing sexual harassment, that it's going to keep going. I mean, a lot of these police departments have an online, that you do an online training. You click the buttons and you've trained. A lot of these departments, women didn't have a bathroom until the last few years. I mean, and they are isolated in a very male paramilitary organization. And I think it is individual leadership that will guide that, whether there's whether there's sufficient training or not. I think is management saying, we're going to look the other way and this is okay? Or are they saying, cut the shit, that's not going to happen here?
I think I would just expand the universe a little bit. Definitely police and fire have been issues, but a lot of my recent cases have been hospitals, surgery departments, finance, higher education, technology, universities. And a lot of those areas didn't have much training. But pardon?
News stations.
News stations, yeah. I mean, it unfortunately is not limited to the police and fire. Elizabeth,
I just want to say, look,
yeah.
Marissa Campagna and we started bringing sexual harassment cases in 1981. This is so discouraging because so much of it is the same. When Farragher and Elliott came in 89 or 91, I forget what year it was, the training industry blew up and management suddenly doubled their revenues by being able to go out and train everybody. It clearly hasn't worked. It just has not worked. The Me Too movement has shown that still 20% of people are sexually harassed. And so what I'm interested in is, do any employers or any unions have any new tools for monitoring their training? For saying this training is utterly ineffective, we're getting the same number of complaints. Or this training is effective because it's interactive and it's empathy training. Or are there any studies or tools that big employers like Facebook or Google or Lyft are implementing individually that are more effective in monitoring or reducing the rampant sexual harassment that is allowed even among highly educated, highly professional environments?
Yeah, and I think I'm going to kick that one over to Jackie Kugel over here.
So, I encourage you to look at the draft guidelines for the EEOC in 2016. There are pages on what is effective training. And I will tell you, at least with respect to what's going on at the MCAD, in terms of what we're making sure in the MCAD train-the-trainer programs getting pushed out there, it already did, to tell you the truth, model a whole lot of what's in those guidance. You've identified the things that we know make training effective. Interactivity, number one. All the buttons, they don't work. But in addition to that, the thing that's really being pushed now, which I think is a little bit different, is empowering employees on bystander training. So we've adopted and pulled in to the training something we haven't done before, which is looking to the Title IX training about bystanders and making that a component and an element of workplace harassment training and empowering employees to own pieces of their workplace. To say, we want to hear about this. You are not a bad person. You are a good person when you bring forward a complaint because you're a bystander doing what we're asking you to do. And we have added the tagline, the enough standard, which is not ours. It comes from Title IX. It comes from Title IX training. So I do think there are improvements in training, and I will applaud, and as a management side lawyer, I don't do this every day, the EEOC for jumping on this in the beginning of 2016, and frankly, those draft guidelines haven't gotten out largely because of the change in administration, and they're sort of stuck. But they're available, and they're a very good tool to use to evaluate whether or not the training that's being provided is effective. The other thing I'll just say about police and fire, I will say among the hardest groups culturally to train, because they're a paramilitary organization. I don't think really it's we don't care about it. I think it's culturally, in part, the work is very hard, and so there's a lot of excuses for behaving in certain ways because of the, because I've heard people say, listen, this is really scary. And so how we interact with each other and how much we can depend on each other, it's important for us to have this fabric as we walk into a burning building. Of course, my response is that doesn't mean that you get to grab and grope people or make inappropriate statements about protected characteristics. That's not okay, but it's a hard thing to unpack. But I have to tell you that many of our departments locally are doing 2 to 3 hour interactive trainings, and I can tell you that because I've done it. I'm not saying it's working, so maybe I'm
Well, then fortunately it's an annuity. You'll get to keep doing it. With that, I thank everybody. I appreciate the panel. I think interesting topics, and I'm encouraged by the turnout this year. We were a little concerned. It was slow in building, and I was wondering whether we should keep doing this, but it looks, and a lot of new people I haven't seen before, so that's great. So
special thank you to Mark and Ira. Please notice that we had 5 women panelists and Mark. Special thank you to Carl. Special thank you to Morgan Brown and Joy, who are hosting our post-panel reception and nosh and a little bit of cocktail. And you guys were fabulous. One more little plug: we're doing a Me Too panel for women in the law in May, and we secured 2 really interesting attorneys this week. One is the Cosby prosecutor, and the other is Christine Blasey Ford's attorney. So it should be great. Look forward to that in May.